Okay, Map v. Ohio. This court held that the doctrines of those amendments apply to all invasions on the part of the government and its employees of the sanctity of a man's home and the privacies of life. It is not the breaking of his doors and the rummaging of his drawers that constitutes the essence of the offense, but it is the invasion of the indefeasible right of personal security, personal liberty, and private property. Uh, that tells you right there, you don't have to give them any of your financial documents. They have to prove that you have committed some offense before any evidence can be used against you. Period. They can't make you give over evidence and charge you with some offense if no injury in fact has been proven and there's no fault that or no proof of fault that your conduct caused the injury. They have no authority to use anything against you. You can wave your bank statements in front of their face and say, I got millions of dollars and you can't touch it. They can't do nothing. Any forcible, compulsory extortion of a man's own testimony or of his private papers to be used as evidence to convict him of a crime or to forfeit his goods is within condemnation of those amendments. Clear as bells. It's just, that's one of the most clear statements that you can get in any lawful documents, because I'm telling you, they're word wizards. They change the wording of everything. The court noted that constitutional provisions for the security of person and property should be liberally construed. In other words, they can't mess with it. Liberally, I mean, they any way, shape, or form you can say no, and they can't do anything. They can sit there and tell you all day that they can, but that's just threats, threatened abuse of the legal process every time. It is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Stealthy, you know what stealth means. It means secret, private, invisible. It's an encroachment. It's a violation of your rights. Jurisdiction, the power and authority constitutionally conferred on a court or judge to pronounce the sentence of the law or to award remedies provided by law. A remedy has to have an injury provided by law upon a statement of facts proved or admitted. You have to admit to a crime or it has to be proved. They just can't make stuff up and then hit you up for it. That authorized by law to be the subject of the investigation or action in favor of or against persons who present themselves. That's another key one. When you go in there, you're giving yourself over to them. Don't even go to court. Who are brought before the court in some manner sanctioned by law. Sanctioned by law. Well, by law means substantive law, which is that part of the law which courts are established to administer as opposed to rules. I mean, that's it right there. Opposed to rules. Every child support law they tell you it's a law, statute, it's all just rules. Most of it's agency rules, unless you're before a judicial family officer. If you're before a judicial family officer, they've probably got something against you. I'm not taking that side of it. I'm not even arguing that side because I don't know the elements that they've found to charge you with a crime. I have no idea. That's not my concern. I'm talking about the fraud, the agency rules, because that's what it is. It's fraud. In Weeks v. United States, the Fourth Amendment put the courts in the United States and the federal officials in the exercise of their power and authority under limitations and restraints forever secured the people, their persons, houses, papers, and effects against all unreasonable searches and seizures under the guise of law. The guise, the fraud. That's a child support scheme. They can't tell you it's a law, it's a fraud. And the duty of giving it force and effect is obligatory upon all entrusted under the federal system with the enforcement of laws, specifically dealing with those with the use of the evidence unconstitutionally seized. If they compel you to turn over your financial documents or DNA without charging you with some injury in fact, it's unconstitutional. The court concluded, if letters and private documents can thus be seized and held and used as evidence against a citizen accused of an offense, the protection of the Fourth Amendment declaring his right to be secure against such searches and seizures is of no value. They're telling you, if you're accused of an offense, if there is an injury, then you have to give over your papers, documents. And so far as those thus placed are concerned, might as well be stricken from the Constitution. The efforts of the courts and their officials to bring the guilty to punishment, praiseworthy as they are not to be aided by the sacrifice of those great principles established by years of endeavor and suffering which have resulted in the embodiment of fundamental law of the land. Finally, the court in that case clearly stated that the use of seized evidence involved a denial of the constitutional rights of the accused. They just can't take your stuff without proof that you've done something. For the first time held that in a federal prosecution, the Fourth Amendment barred the use of evidence secured through an illegal search and seizure. It gets better. Conviction by means of unlawful seizures and enforced confessions should find no sanction in the judgments of the courts. So they can't force you to say, okay, I make this amount of money and I just keep it for myself. I don't pay, this or that. They can't force you to say that, okay, here's my financial documents. They can't force you to admit that, yeah, I went out to eat last week instead of paying my child support. That's all testimony used against you without ever proving a crime. It's unlawful. It states it plainly. It's unlawful. I've had them do that to me. I've had them go in there and, well, have you gone out to eat? Yeah, I've gone out to eat, or I've bought, Burger King or something like that. You should have paid your child support out of that money. Who the hell are these people to tell me what to do with my money? But that's what they do. That's their role. But anyway, here's another one. Such evidence shall not be used at all. That's what he's talking about right there. They can't compel you to convict yourself. That's a violation of the Fifth Amendment. And they can't steal your papers or force you to give over your financial statements. That's a violation of the Fourth Amendment. And if they do it without a injury in fact, that's a violation of due process. Due process means the process of law is owed to we the people. It's owed to us. They only have just powers. Just is right and in accordance with the law. That's all the power they have. They have no authority otherwise. There are many considerations which lead to the conclusion that the power to impair contracts, such as I'll do this job for this amount of money, by direct action to that end does not exist with the federal government. They have no authority to impair your contracts. As soon as you sign that agreement, the first thing they do is take a loan out in your name. The next thing they do is send a damn notice of wage garnishment to your job. That's all they're about, collecting that money. One of the objects of the Constitution expressed in its preamble was the establishment of justice, and what that meant in its relation to contracts is not left to inference or conjecture. I got that right here. Inference means based on conclusion of evidence, and conjecture means based on an opinion or incomplete information. So it's not left up to them to determine whether it's by evidence or opinion. They have no authority to impair your contracts by evidence or opinion. And everything in child support And the agency side, the administrative side, is by opinion. Opinion alone. It's in their opinion that your kids will suffer if you don't make a certain amount of money payment every month. I'll try to finish this up real quick. I'll just come back to it. It'll be part 3. Hang on.